Morning. I am Muralidharan. I am now presenting the subject on vicarious liability. The vicarious liability. It's a situation where one person is liable for the act of others. So, if someone does any wrong act which will affect the employer, especially as per the terms of principles of quid facit persi alium facit persi. Now we are going to see furthermore on this topic. Employers are vicariously liable for the tort which their employees commit during the employment. There are various examples of liability. Liabilities of principal and agent, liability for master and servant, liabilities of partners in each other tort. Now, there are some of the liabilities only can be called as a vicarious liability. Number one, relation. The relationship between the wrongdoer and the other party. There should be some wrong act which has been done by other, and there should be some relation between the employer and the employee. That is called the master and the servant relationship. Here, if you take in the case of contract of service, here the master servant relationship is there because a person is exercising his skill, and he is getting money out of it by a way of wage and salaries. So there is a relationship. When the term called the contract for service, we are assigning our job to the some other vendor or some other outsourced contract. Like we are inviting AC mechanic for to repair our home based work or for the industry based work. We doesn't know we from where he is coming and other thing. Like some of the agencies are now available in and around Chennai, online services and all. We are getting services by booking in the website and all. We are getting the people. So we doesn't know who is the master, who is the servant. In this case, we are not liable for any wrong act done by the person. No, the ratification. Here, the instructions, manuals, SOP has been given by the master to the servant. In this case, the vicarious liability will attract. That is what here about this. And the vicarious liability also related to Indian Penal Code, Section 149 of IPC, which reads that unlawful assembly commits any offence in furtherance of common objective, every member of that unlawful assembly will be held liable for that offence. Section 154 of the IPC. Here, the owner occupier of the land. Say, for example, some employer is discharging their effluent, effluent into the common land or agri land adjoining to the factory. Then the employer is held liable under the section 155. That is called the vicarious liability. Section 155, 4 of section 4 of 155. Also, vicarious liable of the owner or occupier of the land for omission of their agent or the manager if any activity to take place in land and the manager not to prevent illegal activity happening in their property. The some other sections, section 5 of 156, also talks about this. Section 269 of section 6 of 267, 268 of 7, all these things are talks about vicarious liability, like public nuisance has been created by the master. And vicarious liability arising out of lending the servant. Here, as I already said, the AC mechanic is coming from some other services, but we are instructing, we are controlling, we are getting the labor from them, and we are only giving the instruction. In this case, the vicarious liability will apply. And there are few essentials. There should be certain relation between the two parties, and the wrongful act should be in such a way that it is connected with the relationship. So these are all some of the essentials they will be considered while we are arriving that act as a vicarious liability. And And the principles of liability, respondent superior, damages, avoid exploitation of the servant, historical reasons, public policy, bitways of these are all the some of the principles there to be considered when we are arriving that act as a vicarious liability. And some of the case laws which are observed about the vicarious liability. In the first case, Puspabai Purushottam Udeshi versus Ranjit Ginning and the Processing Company. Here, the deceased was traveling in a car driven by the manager of the respondent company and it met with an accident as a result of which he died. The dependents of the deceased filed a claim and the tribunal allowed the damages but on appeal to the High Court, it was set aside on the grounds that the accident doesn't make the respondent company liable. But in the Supreme Court, observed that the accident has occurred due to the negligence of the manager who was driving the vehicle in the course of his employment. Therefore, the respondent company was liable for his negligence of the act. Here, the company is not liable because the manager doesn't know the driving, but he took the car and he met with an accident, and the deceased family doesn't have the right to claim against the company. In the case of Pradeep Kumar versus Postmaster General, the some people are depositing the money in the post offices for their future or savings and account and other thing. In the post office, the officers or some of the staff took the money by way of fraud. Whether the post office is responsible or the person is responsible. Here we have to take into consideration that whether the officer of the post office were negligent, whether there are contributed negligence on the part of appliance, whether the post office were liable for the fraud committed by the employee. In this case, the employee as individual are capable of being dishonest and committing the act of fraud or wrong themselves or collision with others. So the post office is responsible in the case of course of employment or binding the bank or post office the instance of the person. In the case of JK Industries and other chief inspector of factories and boilers and others, here the court observed that then they referred to the Tesco decision, held that the person in charge is responsible for company's action under strict liability statutes. The same observation has been done in the PC Agarwala versus Canada wage inspector, Madhya Pradesh and others. Supreme Court in the case of Baragadara Chemicals versus State of Saurashtra. In this case, the right of the master to supervise and control the execution of the work done by the servant is a prima facie of test. So here the employer should supervise and control if we consider that work is big, done a wrong act done by the employee. In that case, only vicarious liability will apply. The nature of control of the may vary from business to business, and it is incapable of precise definition. The employer does not need to prove to have the exercise the control of the employee work. The test of control is not universal application. There are many contracts in which the master could not control how the work was done. In the case of Rajasthan State Transport Corporation versus Kailasnath Kothari, a bus and the driver were hired by the RSTC Corporation from the private owner. The bus met with an accident. In this case, RSTC was held liable and not the private owner because of the following reason. Here, payroll of the private owner, his service, and the complete control were transferred to the RSTC Corporation. The RSTC was the one who directed, instructed, and commanded the driver. So, Justice Anand observed that the original employer can establish that which lending the servant effective control over him was also transferred to the hirer. So, vicarious liability will apply upon the RSTC corporation. In the case of Sitaram Modilal Kalam versus Santanu Prasad Jaisankar, but here driver lent to the taxi cleaner and to take it to the RTO office for driving test. The accident happened when the cleaner was driving and while giving and driving the test. So the driver was then not in the vehicle. It is clear from the fact that When the accident happened, the car was not used as a taxi for the owner's business. The car was then engaged in the cleaning work which had no connection with the owner business. So here the acted beyond the scope of employment, which was to drive the car as a. The same thing was observed in the state of Rajasthan versus Vidyarthi. But here the Supreme Court observed that some of the by act which wrong act which was done by the employees of the state government, and the state is responsible for the wrong act done by their employees. In the case of State Bank of India, Mrs. Shyamala Devi, here the husband friend was took the money when she asked to deposit it to the bank, but the bank is responsible for the act of the employee because it is observed that it is in the course of employee. In the state of Maharashtra versus Kanjamala, the same thing was observed here. So many of the cases here, the employee which are directed by the employer and the controlled direction has been given by the employer, surely it will attract under the Vicarious Liability. I come to one conclusion on the concluding the subject that my observations are here and there. One is the employer and the employee relationship should be there. The employer given the direction and the control over the act of the employee, and the paymaster should be the employee. Say, for example, if I am giving the instruction, controlling, and paying the money for the work, then I am the master. Here, I am responsible for the wrong act. Thank you.